Hey guys, the NFA is facing its biggest constitutional test yet, and let's talk about it. What's going on, everybody? Jared here from Guns and Gadgets. Today we're going to talk about what could become one of the biggest Second Amendment lawsuits in decades. I'm not exaggerating, and that's saying a lot considering the last 2 weeks here with litigation in the Second Amendment community. 2 landmark Supreme Court cases as well. For nearly a century, the National Firearms Act has been treated as one of the untouchable pillars of federal gun control. And for generations, Americans have simply accepted that if you want a suppressor or a short-barreled rifle or certain other firearms regulated under the NFA, you had to jump through federal government's hoops. Registration, fingerprints, forms, background checks, waiting periods. And that's just the way it's always been for 91 and a half years, until now. Because one of the nation's premier Second Amendment organizations has just filed a major brief that argues the legal foundation supporting much of the National Firearms Act has completely collapsed. And here's the really interesting part. They're not simply arguing that the NFA violates the Second Amendment. They're arguing that Congress may no longer have the constitutional authority to enforce major portions of it at all. Those are 2 very different constitutional arguments, especially when we get into how the government is holding up their defense. Hint, hint. Justice Thomas just wrote something that I talked about 2 days ago. All right, those are 2 different constitutional arguments there of how the government thinks that it can keep this NFA going. Today I'll break down exactly what Firearms Policy Coalition is arguing in court. Let's discuss why this lawsuit even exists. Let's look at how the federal government is trying to defend the law, because that's going to be eye-opening. And we'll talk about why this case could eventually have consequences far beyond suppressors and short-barreled firearms. Now, before we dive in, if you enjoy factual, constitutional-based coverage of the fight for our Second Amendment rights, please hit that subscribe button and turn on the notifications. It helps this channel out immensely, and it doesn't cost you a nickel, it just costs you 5 seconds of your time. Only a small percentage of people who watch these videos are actually subscribed, and subscribing is one of the easiest ways that you can help us continue bringing this coverage every single day. So let's get into this. First things first, this is not a court decision. Nobody has won anything yet. Nobody has struck down the National Firearms Act yet. What I'm talking about is an important filing submitted by Firearms Policy Coalition in an active federal lawsuit. It's the plaintiff's response to the federal government's arguments and their request that the court grant summary judgment in their favor. In other words, they're telling the judge, Your Honor, the law is clear, the Constitution is clear, there aren't any genuine factual disputes, so rule in our favor right now. And the government, of course, disagrees. The Department of Justice says the remaining portions of the National Firearms Act are still constitutional and should remain fully enforceable. And I got the Constitution on my walls. I reread it again before I hit record here. I don't see anything about anything the National Firearms Act does anywhere in the Constitution, which means it's unconstitutional. So this is an active legal battle, but it's an incredibly important one as well. To understand why this lawsuit matters, you have to rewind almost 100 years, back to 1934, when Congress passed the National Firearms Act. Interestingly, Congress didn't present the NFA primarily as a criminal prohibition. Instead, as you should know by now, it was structured as a tax law. And that's a critical distinction here, because rather than outright banning certain firearms, Congress imposed substantial taxes on them, making them and transferring them, I guess I could say. So you can't make one or transfer them unless you pay the extra $200 along with registration requirements, and then you got to do all kinds of, jump through hoops and wait. But I will say, again, nowhere in the documents did I read, and correct me if I'm wrong in the comments, I didn't see anywhere that these things are dangerous, but if you give us $200, they're not dangerous anymore. I don't remember seeing that. At the time, a $200 tax wasn't just expensive, it was enormous. Adjusted for our inflation, it would be several thousands of dollars today. And Congress knew exactly what it was doing. The tax itself became a significant barrier to ownership. And according to the plaintiffs in the lawsuit, that historical fact is incredibly important because the NFA was enacted under Congress's taxing power, not as a general exercise of federal police power. They point to the statute's history, its structure, and its legislative record to support the argument. And before I keep rolling, I want you to think of something, guys and gals. We are defenders of ourselves and others. Could this happen to you?
My name is Eric Salisbury. I was involved in a self-defense shooting in Portland, Oregon. I had been a member of AOR for about 6 months before this happened. I was amazed at the response of the AOR legal team. From the moment that I called and talked to Andrew, they were on the case and they were talking to the detectives, to the police officers. If you own a firearm, you've got to be able to protect yourself on the legal side. This team will do that for you.
Guys, if you carry a gun for self-defense, the biggest threat you face might not come from the criminal, but from the government coming after you for defending yourself. That's why you need attorneys on retainer in your corner. And we are witnessing things happen in our streets, in our nation, that should make you realize that you are your own first responder. Attorneys on Retainer is backed by Attorneys for Freedom, the only national law firm in the nation that focuses exclusively on self-defense cases. That is all they do. From red flag laws to use of force claims, they're ready to stand between you and a system that's often stacked against gun owners. And here's the bottom line. If you can reasonably assert self-defense, AOR has your back. No caps, no loopholes, no nonsense, no gimmicks. Just real attorneys fighting for your freedom in every single state in our country. And it's the best team assembled, the best, most aggressive freedom attorneys in the business. I know every single one of them personally. And they are who I have chosen to fight for me, my children, my wife, and our freedom. And right now, if you use code GNG at the link down below or use my QR code, it's easier, you'll save $50 on your individual plan sign-up fee, or $25 off your family plan sign-up fee. Tongue twister. And this savings will run out on July 31st in celebration of America's 250th. So thank you to the entire AOR and AFF team. Let's fast forward to what's going back on here. Congress, they made a major change. The making and transfer taxes for suppressors, short-barreled rifles, short-barreled shotguns, and what's called any other weapons was reduced to $0, while taxes remain in place for machine guns and destructive devices. And that change is central to the plaintiff's constitutional argument. And that's where the lawsuit begins. The plaintiffs are essentially asking one very simple constitutional question. If Congress justified these registration requirements as supporting a tax, and the tax is now $0, can the government continue enforcing the registration requirements anyway? That's the issue. Not whether suppressors are good or whether they're bad, not whether someone likes them. The question is whether Congress still has constitutional authority to require registration under the rationale it originally used. According to Firearms Policy Coalition and several other lawsuits, to be honest with you, the answer is no. They argue that once Congress eliminated those taxes, the registration provisions lost what they call their constitutional tether to the taxing power. And think about it this way. Imagine someone builds a bridge that's supported by a series of columns. Then someone removes several of those columns. Eventually, you have to ask whether the bridge can still stand on its own. It's a simple way to put it. And the plaintiffs here argue that's exactly what's happened with the NFA. They contend the constitutional support for these registration requirements has now been removed. And here's where things become fascinating. The federal government doesn't simply throw its hands up and say, well, you got us. Instead, no. The government advances a different constitutional theory. According to the government's position, even though those specific taxes are now $0, the remaining registration system is still connected to other portions of the National Firearms Act and can also be justified under Congress's constitutional powers. The plaintiffs strongly disagree, as do every American. In their filing, they argue the government is attempting to connect separate provisions of the law in ways Congress never, ever intended when the NFA was enacted. And that's where this case moves into one of the biggest constitutional debates we've seen in years, perhaps decades. Because once you move beyond the taxing power, you arrive at another familiar constitutional battleground, the Commerce Clause. The same Commerce Clause, if you didn't see the video I have floating above this side, Clarence Thomas himself said, this Commerce Clause does not give the government the ability to control every single firearm in America for the rest of its life. So now we've arrived at what I believe is the most fascinating part of this entire lawsuit, because this case really isn't just about suppressors. It's not really just about short-barreled firearms. And it isn't even just about the National Firearms Act. The case is asking a much bigger constitutional question. What are the limits on federal power? That's really what's at stake here. For decades, Congress has relied on a handful of constitutional provisions to pass countless federal laws. The taxing clause, the necessary and proper clause, and perhaps most importantly, the stupid commerce clause. If you've watched this channel for any length of time, you've heard me talk about the commerce clause before. In fact, like I said, if you haven't watched that video where Justice Clarence Thomas gave us warnings that the court has expanded the commerce clause far beyond what the framers originally intended, you need to watch that. This lawsuit dives right into that same debate. And here's what the federal government is essentially saying. Even if the court agrees that these registration requirements are no longer supported by Congress's taxing power, the government argues they can still survive because Congress also has authority under the Commerce Clause. Now, that sounds simple enough on the surface, but Firearms Policy Coalition says not so fast, boys and girls. According to the plaintiffs, Congress never enacted these portions of the NFA as a Commerce Clause legislation in the first place. Instead, they argue the statute's text, structure, and legislative history show it was enacted as a tax measure. And that's how the Supreme Court back in the day upheld it, as a tax measure. In other words, Firearms Policy Coalition is saying the government is trying to change the constitutional justification nearly 100 years after the law was enacted. That's a pretty significant accusation. Now let me simplify this because constitutional law can get complicated in a hurry. The Commerce Clause gives Congress authority over interstate commerce between the states. Notice those words, interstate commerce. Commerce between the states? Historically, that meant regulating actual commercial activity crossing state lines. But over the last century, courts have interpreted that authority much more broadly. Sometimes so broadly that it's mind-blowing. The plaintiffs argue the challenged NFA provisions do not fit within those constitutional limits and cannot simply be justified after the fact as Commerce Clause legislation. Again, this isn't the court saying that. This is what the plaintiffs are asking the court to decide. One thing that I found particularly interesting while reading this filing is how much emphasis the plaintiffs place on the history behind the National Firearms Act itself. It was good. They pointed to testimony from 1934 congressional hearings where an assistant attorney general reportedly explained that the revised bill, quote, follows the theory of taxation all the way through, end quote. They argue that history demonstrates Congress intentionally relied on its taxing authority rather than the Commerce Clause for these provisions. Now, why is that important? Because if Congress built the law on one constitutional foundation, can the executive branch later defend it on an entirely different constitutional foundation? And that's one of the major questions that the court will eventually have to answer here. Now, let's assume for the moment that the court isn't persuaded by any of those structural constitutional arguments. The plaintiffs don't stop there. They also raise an entirely separate Second Amendment challenge. And this is important because even if the court rejected every argument about the taxing authority, the plaintiffs say the registration requirements still violate the Second Amendment. Why? Because they argue suppressors and short-barreled rifles and short-barreled shotguns and any other weapons fall within the Second Amendment's protection. They rely heavily on the framework announced in Bruin, arguing that these items are covered by the amendment's plain text and that the government cannot point to a single historical tradition supporting a complete, comparable federal registration system. Now remember, under Bruin, once conduct falls within the Second Amendment's plain text, the burden shifts to the government to identify a historical analog supporting its regulation. That historical analysis has become the centerpiece of modern Second Amendment litigation. And that's exactly where this case goes. One issue in the filing that spends considerable time discussing is suppressors. The plaintiffs argue suppressors are protected because they are commonly possessed by law-abiding Americans for lawful purposes, including hearing protection and safe firearm use. They also contend suppressors are not dangerous and unusual, and they're not weapons in that constitutional sense. Now, according to the ASA, I saw the number a couple days ago. I don't remember. It's like 6 million suppressors are now in the public's hands. That's pretty much common use, my friends. Likewise, they argue that short-barreled rifles should not fall outside the constitutional protection simply because of barrel length. Again, whether the judge ultimately agrees remains to be seen, but these are arguments the court is now being asked to evaluate. Another interesting disagreement centers on something many people probably wouldn't expect. The federal government argues the NFA registration process is similar to what the Supreme Court described in Bruin when it discussed the objective shall issue licensing system. Of course, FPC, the plaintiffs, disagree, as does America, strongly. They argue the NFA is not a traditional licensing regime at all. Instead, they say it's fundamentally a taxation and registration system, and they argue there is an important constitutional distinction between licensing and registration that courts should recognize. And that may sound like legal hair splitting, but these distinctions often determine how constitutional cases are decided. One word, one historical analogy, one constitutional principle. Sometimes it's all that takes, is just one. So why are so many constitutional attorneys watching this case? Well, because if a court accepts even part of the plaintiff's reasoning here, the implications could extend well beyond this specific lawsuit. Now, I'm not saying this is going to happen. No one knows what the judge will say or feel or decide or rule. And even after the district court decision, whichever side loses is almost certain to appeal. And this case could spend years moving through the federal courts, unfortunately, but it raises constitutional questions that reach far beyond one filing in one district court. Questions about constitutional authority, about the limits of federal power, and questions about how Bruin continues reshaping Second Amendment litigation. Those are big issues that affect every one of us in America, especially gun owners. Not just the plaintiffs in the lawsuit, but all of us. Now that we covered the constitutional arguments, let's talk about where the case goes from here. Because if you're following Second Amendment litigation for any length of time, you already know one thing. Very few of these cases end at the district court. The lawsuit here is no different. Right now, both sides are asking the judge to rule in their favor through what's called summary judgment. In simple terms, each side is arguing that there aren't any material facts in dispute and that the court can decide the constitutional issues based on the law without a need for a trial. Now, if the judge agrees with the plaintiffs, the court could strike down some or all of the challenge provisions as they are applied in this case. If the judge agrees with the government, the challenge provisions would remain in effect. But either way, I would be shocked if the losing side simply walked away. Now, this case has all the ingredients of one that's likely headed to the appellate courts and possibly to the Supreme Court. And depending on how different federal courts rule in similar cases around this country, because there are 5 or 6 big ones challenging the NFA right now, it could eventually present questions that the Supreme Court may be asked to resolve. That's not a prediction, it's just simply recognizing how major constitutional litigation often works, especially in the Second Amendment realm. They develop over time, district court, court of appeals, possibly the Supreme Court, and we've watched this process play out with Heller, with McDonald, with Bruin, with Rahimi, with Haimani, with Wilford and Lopez. It's just the way it is. Guys, I want to know what you think. Do we, the people, have a right to own a suppressor? I'm asking something fundamental here. What limits does the Constitution place on the federal government? Because what's really going on and what's really in our Constitution, guys, it's not a document that grants us rights. Our rights exist independently. The Constitution places limits on the government. The Bill of Rights tells the government what it may not do. And that's a very important distinction for everyone to understand. The Second Amendment does not say the government may allow people to keep and bear arms. It says the right of the people to keep and bear arms shall not be infringed. And those words matter, every single one of them. Guys, I appreciate you so much. Thank you for your time. Please hit the like button. Please share this with others. Turn the notification bell on. And please check your subscription to the channel. Help this channel defeat the anti-gun algorithm. Appreciate y'all. Stay safe, stay armed, and stay free. I'll see you on the next one. Take care.